right now.
And you made a very strong argument that the framers of the 14th and 15th Amendment intended Congress, not the courts, to be the primary defender of voting rights.
If you compare, take the First Amendment, it says, Congress shall pass no law. So it says, Congress, keep your hands off. But the 13th, 14th, and 15th Amendment end, and Congress shall have the power to enforce those post-Civil War amendments by appropriate legislation. So it's affirmatively, the Constitution, instead of being a negative check on what the legislature can do, is affirmatively giving the legislature the authority to implement those amendments.
You were also critical of the court's expansion of the opinion called Northwest Austin, which a few years earlier had avoided a constitutional decision on the Voting Rights Act. That was an example of Chief Justice Roberts avoiding a constitutional conflict by ruling narrowly, but are you sorry in retrospect that you joined Northwest Austin?
I think the result in Northwest Austin was right. This was a water district that had never discriminated, but was in a state that had. The court read the act to say districts, municipalities, counties could bail out. So you could be part of a state where there was discrimination going on, but in your area there was no discrimination. So I think the Northwest Austin establishing that bailout was available to smaller political units was a good thing. And then the chief wrote the opinion, and he put in language that came back to haunt some of us.
Adam Liptak, the very astute New York Times commentator, wrote a piece suggesting that that Chief Justice Roberts often will make a small incremental step and get you guys to agree to it, and then bring it back to haunt you in the future case where he actually rules on the constitutional question. Is that a fair characterization?
Can you give another example?
Other
than the Voting Rights Act?
I guess yes. Campaign finance, where first in the Wisconsin Right to Life case, the Buckley and the McCain-Feingold was not overruled, and then the coup de grace was delivered in Citizens United.
Yes, but Roberts wasn't there when it was upheld. When when campaign finance, McCain-Feingold was upheld.
There was one decision where he and Justice Alito sort of declined to pull the trigger, and then
yes.
They did. And that was when Justice Scalia accused Chief Justice Roberts of faux judicial restraint, which of course is fighting words on the Supreme Court, and maybe that should go in the opera as well. But campaign finance was another, and then affirmative action, which I want to ask you about why you decided to dissent alone in the affirmative action case, but the thought was that here, once again, the majority was avoiding ruling squarely on the constitutional question, but the fear was that the standard was actually being raised in a way that might lead down the road to the overruling of the Grutter case and the end of affirmative action. Tell us why you decided to dissent alone in the Fisher case.
I thought that the court was taking a position that was astonishing if you go back to the origin of the suspect classification doctrine. It came out of a footnote in a decision by, was he then Chief Justice Stone, in the Caroline Products case. This was a justice explaining that for the most part, we trust the legislative process, and the court is deferential, respectful of the laws that Congress passes. So we regard these laws, we presume that what the legislature has done is constitutional. there are two categories of cases, Stone suggested, where that's not the right approach. And one was when fundamental liberties, when the guarantees of the Bill of Rights are at stake, First Amendment rights are at stake. The court is the guardian of the Bill of Rights, and it should see to it that Congress remembers that Congress is to pass no law abridging the freedom of speech or of the press. The other category, cases where the majority was disadvantaging the minority. So then you really couldn't trust the political process. The minority that was being oppressed didn't have the political clout. You couldn't trust the majority to deal fairly with them. That's suspect class. What was suspect was the majority disadvantaging the minority. And over time, it has become race is the suspect criterion. It's not at all what the original idea was. And when a state, in the case of Fisher was Texas, the state university wants to have an affirmative action plan of the most moderate kind. Who is the court to say that that's unconstitutional? So on my part, again, it's being deferential to another decision maker.
You sound once again like you're out. You're being a better originalist than Justice Scalia as well. We have two cases here where you're saying, in fact, constitutional history is on your side, and you're a champion of judicial restraint and of respecting original understanding.
Yeah, well, the Caroline product footnote was an insight that the court had. You know, people think that suspect classification, some people think that it started with the Korematsu case, but it's back there in the days when the court stopped putting down social and economic legislation and recognized that for the most part the legislature should. The question is who decides what's good economic and social policy, not the court, but the legislature. And Caroline Products was such a case, a typical economic regulation case. And the court said what Congress did was okay. And then Stone thinking said, but maybe sometimes we have to be more suspicious about what Congress is doing.
That's what the court said in during the New Deal era, but you suggested in your final sort of blockbuster of a dissent, the healthcare dissent on the Commerce Clause point, that perhaps some members of the court were trying to resurrect the bad old days of economic judicial activism, and you said that the attempt to strike down the individual mandate of the Affordable Care Act under the Commerce Clause had resurrections of the Lochner case, that infamous case from the Progressive era that struck down maximum hour laws for bakers. Are you afraid of a resurrection of economic judicial activism along these lines?
It seemed to me that the Affordable Health Care Act was just the completion of what was started in the 30s with Social Security. The Social Security Act was upheld by the court, and many people thought that after that the court was recognizing that economic and social policy was not its domain. So if the legislature wants to pass a minimum wage law, a maximum hours law, that was the legislature's prerogative. Most countries in the world, most industrialized countries, have universal health care. They had Social Security long before we did. So I saw the Health Care Act as just completing that flaw that the government is putting, that safety net. People will have a Social Security coverage when they're elderly or when a partner dies. And this healthcare was part of that same understanding that government does have an obligation to see that people's basic needs are met. But I understand the resistance. The Social Security Act, the name of the act is the Federal FICA, the Federal Insurance Contributions Act. Well, it was sold to the public as an earned right. You work, you pay an insurance premium, but you're not paying an insurance premium at all. You're paying a tax, pure and simple. That's what Social Security is. It's a tax that we pay so that people who are no longer able to work will be taken care of. But the suspicion of social and economic legislation to see that people responding to the need for the well-being of the public. Anyway, I thought once the Social Security Act, once that was accepted, there would be no question anymore about the Commerce Clause extending to health care.
And yet the majority on that point introduced a distinction between economic activity and economic inactivity, and said if Congress can regulate this kind of economic inactivity, then it will resurrect what you called the broccoli horrible. Tell us about the broccoli horrible and why you were unconvinced that American citizens may be forced to buy broccoli if the individual mandate were upheld.
Yeah.
There was something about frying the broccoli as well, in your opinion, about how attenuated the account of how Americans' health would be improved would have to be in order to accept the premise of the broccoli horrible.
Well, the truth about healthcare, it was portrayed as taking the young and the healthy and making them pay for the elderly and the infirm. But if you think of a person over the span of time, so today you're young and healthy. In the not too distant future, you will be middle-aged, and then you will be old, and then there'll be young people who are paying for you. So if you look at it as a whole lifespan, yes, you're paying a tax when you are young, and the state is not providing services that you don't need, but over the long run, it evens out.
Of course, the question of whether it was or wasn't a tax proved to be central, and there was some comedy about it. During the debates, all the Democrats stood up and said it's not a tax, and the Republicans said it is, and as soon as the ink was dry, they switched, and all the Democrats said it definitely is a tax, and it is therefore constitutional, and the Republicans said it's not a tax, and therefore isn't justified by the
But
taxing power.
that does reflect the debate at the time of Social Security. Social Security was a tax. It was not an insurance premium, but it was sold as not a tax. And even our president tried to sell the health care by calling this not a tax. It was a penalty.
Penalty, yes.
Penalty.
Should that matter, what the president called it? I mean, it proved not to be dispositive.
The president wanted to get the Health Care Act through Congress. And there was a very strong view that no more taxes. We will not enact any more taxes, so call it a penalty.
What did you think of the Chief Justice's decision to uphold it as a tax?
Oh, I thought it was interesting that although he saw the Commerce Clause as limited, he saw the tax clause as expansive. Congress can tax as it will, and it's not hemmed in by. How could anyone think that health insurance doesn't involve commerce? Think of the criticism today of the Health Care Act. It is said in some quarters that this will be the ruination of small business. Well, small business is commerce, right? It is very difficult to understand how that cutback on the reach of the Commerce Clause came about, and I think it will not have staying power.
What do you mean? Will it be overturned?
That view, yes. And we will get back where we were ever since the late 30s, when economic and social legislation is recognized as the proper domain of the Congress, and that is, as devoted as you may be to your particular state, there are so many things in this highly industrialized world that states can't do, that have to have a national solution.
That point about the national solution was another example of you being a good originalist, because you said that the framers of the Constitution were concerned about the collective action problems in the Articles of Confederation and wanted to empower Congress to act when the states were powerless to coordinate their actions together.
Yeah.
So you do believe the Commerce reading will be overturned eventually. Are you concerned in the short term that it might lead to the